My name is William Clayton. I'm excited to talk with you today about the Johnny Depp Amber Heard jury trial, and in particular, the closing arguments. I've tried over 100 cases, and I've won over $150 million in jury verdicts. In Florida and Nevada, I'm a board civil trial specialist, and I'm a member of the American Board of Trial Advocates, which is widely considered the best of the best civil trial lawyers in the US. I am founder and partner of Clayton Trial Lawyers. I'm excited to talk with you about 5 takeaways from the closing arguments in Johnny Depp versus Amber Heard jury trial. I preface my remarks by saying I listened carefully to every sentence of the 4 hours of closing arguments, but I did not listen to the trial testimony, save maybe 2 to 3 minutes of segments of the jury trial. My remarks are fresh to you based on my impression of the over 4 hours of closing arguments from a 6-week jury trial. My first takeaway is the Amber Alert. This was the biggest mistake by trial counsel. This was the biggest mistake by Ms. Heard's counsel, other than her fake crying. Benjamin Rottenborn, in the most famous case of his lifetime, his moment in the sun, he was struck by lightning when, during his closing argument, Judge Penny Ezkarate's cell phone goes off and she announces Amber Alert. Everybody in the courtroom's phones were going off too. You could see everybody's focusing on their phones, and certainly the members of the jury would have been focusing on their cell phones, particularly in the advent of Robb Elementary. What did Mr. Rottenborn do? Instead of stopping and waiting for all the cell phones to stop going off, he continued to present his PowerPoint presentation as if nothing happened. He had to stop. He had to stop until all the alerts stopped on the phones. And then he had to say something like this: "That was not an Amber Alert. Please look at your cell phones. You can see it was a storm alert." But it's like the Johnny Depp trial team during this case. They've been calling it an Amber Alert for 6 weeks. And now you have the power to shut that position down. My second takeaway is a Bible phrase that you've seen or heard, which is asking you shall receive. In a trial lawyer's parlance, it is, if you don't ask, you don't get. Both sides made a mistake here. I'm reminded of questions asked once of Jerry Spence, one of the US's most famous civil trial lawyers. He was asked, "How do you get such large verdicts?" His answer was, "Because I ask for them." In this lawsuit, Mr. Depp wanted $50 million. In closing argument, however, Mr. Depp's lawyer, Camille Vasquez, said the case is not about money. He wants his reputation back. I don't remember plaintiff's counsel asking for a single dollar from the jury. On the other hand, Ms. Heard's lawyer also failed to ask for damage amount on her counterclaim for an alleged $100 million. She said Ms. Heard had over $6 million in legal fees defending herself in court, including UK, but she didn't even ask for them. At the end of her closing, she said, "I'm not asking for 100 million. She asked the jury to be fair and reasonable. Then Ms. Brettenhoff said 350,000 in punitive damages. It could be that both sides did not want to put a big number out there for fear that what's perceived as an exaggerated damage amount could cost them both the entire case. My third takeaway is don't let the jury know you're nervous. At one point in closing by Ms. Heard's lawyer about Mr. Depp losing part of his finger, Mr. Depp's attorney, Ben Chu, leans back and looks to his left, behind Mr. Depp to Ms. Vasquez. Then later, on the train to Asia, Ms. Vasquez could not stop wringing her hands. Ms. Brettenhoff could not get the stand in the shoes analogy straight. She had Mr. Waldman standing in Mr. Depp's shoes, Mr. Depp standing in Mr. Waldman's shoes. Picture that. Last, if you get nervous and have a serious case, don't bring your happy voice to closing argument and don't talk too fast. Ms. Heard's lawyer should not call Mr. Depp Johnny in closing argument, and she should not call her own client a gold digger. Fourth, Ms. Heard's lawyer needed to get their theme straight. Out of the box, Mr. Rottenborn said the case was about the First Amendment. All right, so that means she can say anything, right? But no, then he said, it's about blaming Amber for what she did not do. Then he switched and said, If Amber was abused one time, she wins. Within minutes, he told the jury they were abusers too. None of us are perfect. We are all abusers, he said. I'm thinking, did he learn that from a jury consultant? On the other hand, I love Ms. Vasquez's turn of the phrases. She's lied too many times. Her story is a constantly moving target. Words matter. She gave a performance of her life. Those were great. Mr. Depp had a very good jury consultant and outstanding lawyers. Fifth and last, both sides need better trial tech teams. The audio is not working for each of plaintiffs' counsels as they stood up for their portions of closing argument. Mr. Chu, in bringing up the jury verdict, did not call out certain of the questions that he wanted the jury to answer yes to, each of those 7. And then the Johnny Depp text messages. They were not called out and they were seen in such small text. They should have looked something like this. I have a prediction on who's going to win the case. I was right on predicting the jury result in state of Wisconsin versus Kyle Rittenhouse. I have a high level of confidence here. I will also be talking with you about other topics as the jury is still out.